Tonight, NBC News learning from multiple sources prosecutors will call their star witness Michael Cohen on Monday. He called himself Donald Trump's fixer, now a vocal Trump critic. Cohen unleashing on his old boss in his book and on social media, spotted online this week wearing a T-shirt depicting Mr. Trump behind bars. The judge today directing prosecutors to inform Cohen that the judge is asking him to refrain from making any statements about the case or Mr. Trump, but not placing a gag order on Cohen. Mr. Trump remains under one, barring him from attacking witnesses and the jury.
It's a disgrace. It's not a case. There's no crime. There is no crime, and they failed to show a crime.
Cohen, a critical witness for the prosecution, as the jury has now read his text messages, heard his voice, and seen evidence that he paid Stormy Daniels $130,000 just days before the 2016 election so she couldn't derail the campaign. The defense says her story of sex with Mr. Trump was false, a shakedown for money brokered by Cohen, making his testimony and credibility on the stand essential. Mr. Trump has pleaded not guilty to the charges of illegally disguising his reimbursement checks to Cohen, his former attorney, as, quote, legal expenses to cover his tracks. The face-off between the presumptive GOP nominee and Cohen likely to be one of the most dramatic of the trial. Cohen comes with baggage, including previous convictions for campaign finance violations and lying under oath. Meanwhile, today, the jury hearing more from former Trump aide Madeleine Westerhout, who sat outside the Oval Office and confirmed Mr. Trump met with Cohen at the White House in 2017, where prosecutors say they devised their reimbursement scheme. But she testified the former president signed checks without reviewing them first, contrary to what Mr. Trump said in his book and other witnesses said at trial.
So, Laura, we're 4 weeks into this case right now. Has the prosecution appeared to check all the boxes they needed and wanted to check?
Lester, the challenge is that so far this jury has not seen a single document, a single tape, a single piece of evidence directly showing that Mr. Trump himself falsified any records or caused anyone else to do so. Instead, they appear to be relying on Cohen to connect those dots for him, and that's the challenge, Lester.
Thanks for watching. Stay updated about breaking news and top stories on the
All right, and happy Mother's Day, and welcome back Inside the Law. I'm your host, Philip Holloway. Before we go any further, I did want to expand on the thought just a minute of Mother's Day, and I wanted to personally wish each and every mother out there watching now live or perhaps watching the replay of this video a happy Mother's Day. I hope it was an awesome day. For those of you whose mothers may have passed, remember today because this is the day where you remember your mother and all the things that your mother did to help you have a wonderful life. And so today is the very special day for all moms everywhere. So I hope you were able to spend it with friends and family and had a great day. Well, so today is the day before the Michael Cohen testimony is expected to begin. We have lots that we could talk about in the terms of the Trump trial. We have all of the things that happened last week, you know, the Stormy Daniels disastrous testimony that I think the DA may wind up regretting in the end. We have the fact that little to no, in fact, I think actually zero evidence that shows that Donald Trump, the accused in this case, has committed any kind of crime, let alone having, you know, booked something on the books of the Trump Corporation in an erroneous way. I was talking on a legal panel, Megyn Kelly's show the other day, and this topic kind of came up. The question was like, okay, what would you, if Donald Trump was your client, what would you say to the man as far as, or whoever his job it was to write these things in the books? How would you tell your client to book this? Well, it is in the nature of a legal expense. Okay. It's because there's a contract involved. It's a non-disclosure agreement. It's a contract. That is a legal expense. And to the extent that, you know, Donald Trump had it wasn't his job basically to keep the books per se of the Trump corporation. So there's a lack of criminal intent. There's so many ways that we can, I think, reasonably and fairly pick apart the ridiculous case put up by District Attorney Alvin Bragg in Manhattan. But there's not enough time in the day. Today, I want to talk about Michael Cohen. All right. Who is Michael Cohen? Well, Michael Cohen is going to be the witness that we are told will take the stand tomorrow, former Donald Trump attorney, who is, I guess, according to Bragg, he's going to be the guy who's going to basically bring this home, basically tie all this up and show the jury, if he can, why Donald Trump is the fraudster. Okay. And here's their star witness. I mean, this is the guy who is going on TikTok. He's apparently making money on TikTok. This is the star witness. And so we're going to talk today about what the defense lawyers would do. What might I do if I were cross-examining Michael Cohen? Before we get into too much of the weeds on that, there's 330 people in the live stream right now. Welcome to each and every one of you. I see the live chat is absolutely already kicking off. Chat boss Megan may or may not be able to make it in here tonight. For those of you who are asking or wondering where she might be, it is Mother's Day after all, and I understand people still sometimes have plans with family, and that's obviously way more important. But anyway, welcome to each and every one of you. Thank you so much for spending part of your weekend with me and with each other, because after all, that's what we do here inside the law. We go inside the law to learn about how the real justice system works. We do it in the context of cases that are actually in the news every day, things like the Donald Trump trial, but next week it may be something else, and next month it'll be something else. But here we have a golden opportunity for those of you who maybe have some intellectual curiosity to learn about how lawyers deal with witnesses like Michael Cohen. So there's a term in the law. It's called impeachment. And impeachment, well, let me just bring up another graphic for you to take a look at what exactly is impeachment. Impeachment of a witness refers to the process of discrediting or undermining the credibility of a witness during a trial by presenting evidence or asking questions that contradict their testimony or reveal a bias. We're going to come back and talk more about that. Inconsistency, we're going to talk more about that. Or falsehood in their statements. And of course, we're going to talk about that. It is a common strategy used by attorneys to challenge the veracity. That means the truthfulness of a witness and to cast doubt on the reliability of their testimony in court. It is to cast doubt on the reliability of their testimony in court.
There's nothing more powerful than the odor of mendacity.
All right. So this is impeachment, and it's not the same kind of impeachment that we talk about in the context of, when a president of the United States or a cabinet officer or a judge is impeached by the House of Representatives. It's not that type of impeachment. It's a process in the law that we use to deal with witnesses who we think, for whatever reason, the jury should not believe them. Impeachment is not always all that adversarial, although sometimes it can be. And when a lawyer who has a witness on cross-examination has a lot of material to work with for impeachment, it can actually be quite a lot of fun, particularly if you have a witness that's a convicted felon or who has prior inconsistent statements, all of which will apply here. And we're going to get into that just a bit more here in just a moment. There's now almost 500 people here. Go ahead and hit that like button if you don't mind. That helps people find this show, people who might might find it useful, who might have some interest in the subject matter, have an intellectual curiosity, or who might like the subject matter. So please go ahead and hit that like. And by the way, I'm closing in, albeit a little bit slowly, I'm closing in on 30,000 subscribers. So if you haven't subscribed, please consider doing so. That also will help us to grow the channel. And if you have subscribed, thank you. But also get your friends, your family, your neighbors, your coworkers, anybody that you can think of, and suggest the show to get them to subscribe too, because that will help us out and it won't cost you anything. All right, so let's moving right on to what can we do if we are the lawyers in the case and we are confronted with this witness. All right. In order to put this in proper context, we're going to have to talk more about sort of the subject matter of what impeachment is. Okay, so let's go through this. I'm going to go ahead and make this for you. I'm going to make this full screen so that you don't have to see me and you can see this, and that way I can still speak with you. All right, so the key concepts again: witnesses' credibility may be impeached by any party with a good faith basis for making the impeachment. A witness may be impeached with evidence that shows a defect in his or her perception, memory, or truthfulness, such as evidence of bias, mistake, character for untruthfulness, or prior inconsistent statements. Most types of impeachment may be proved through extrinsic evidence as long as the matter is material and is subject to the court's discretion to avoid unnecessary or undue prejudice, confusion, or delay. All right. So the legal overview here, the federal rules of evidence, and then each state, by the way, has their own very similar rules of evidence, and the concepts are pretty closely uniform from one state to the next. So the rules allow for the credibility of any witness to be attacked by the state or the defense, even if the witness was called to testify. In other words, you can call a witness and you can impeach them yourself. That used to not be the rule, but it is no longer the rule. There are certain types of impeachment, okay? And we're going to get into these in just a little bit more detail. Bias is where a witness may be impeached with evidence of bias. Much latitude is allowed in showing the bias, hostility, or other interests of a witness with respect to the case. All right, since we're on the subject of bias, I want to share this with you. Okay, so this is apparently a recent image. This Michael Cohen was going on TikTok. I'm sure some of you are familiar with this. He was going on TikTok. He's been saying and talking lots about the case. He's been saying all sorts of things, but he goes on recently wearing this shirt showing Donald Trump in a jail cell. And so, you got to ask yourself, okay, is this evidence of bias? Well, of course it is. So, this is one of the first things that I, quite frankly, that I would hit him with if I am if I'm going to be cross-examining him before we do anything else where he can explain away things. I'm going to show the jury before I do anything else that this witness should not be believed, because he goes so far as to go on TikTok, where, by the way, he's, trying to profit off of his testimony and his involvement in this case. And he's wearing a shirt that's showing the defendant in the case in an orange jumpsuit behind bars. All right. So we're going to have to hit him with that right out of the gate. You're going to show the jury this picture. You're going to get him to identify, yes, in fact, this is him. And you're going to have a big giant blow up of this. And you're going to be waving it around in front of the jury before you really get out of the gate, because you're going to show that this guy, no matter what he says, he's there on a mission, and his mission is to put your client in jail. Therefore, his testimony should be taken with a grain of salt, if that, because he's got obvious extreme bias. All right. So moving back along, we're going to go back and finish looking at impeachment and add this guy back to the stage. The next type of impeachment is contrary evidence. Now, this sometimes is not all that exciting. So let's just say a witness takes the stand and says, I saw Phil holding a gun out in the street at 3:00 in the morning. All right. So fast forward to the next day with a different witness. And then so let's just say my lawyer then puts up evidence to show that Phil was asleep in bed 300 miles away at that time of the morning. That's what we call impeachment by contradiction, bringing contrary evidence. Okay. So in other words, if the witness says the sky is blue and you have some other evidence that says the sky is actually green, then that would be impeachment by contrary evidence. All right. Inability to observe or remember. You always get to challenge the witness's ability to, understand what they're seeing, to recall it, to relate it to a jury, which sometimes, by the way, is years and years later. And over time, our memories change, and over time, our perceptions of things sometimes can change. And so that's a way to impeach a witness, but it's not all that exciting, but it is a very valid it's a valid tactic. Next, we get into some of the more exciting ones: character and conduct. Okay, you can impeach a witness's character, such as their character for truthfulness or lack thereof, a prior conviction, prior inconsistent statements, and all of these are going to come into play in the Michael Cohen case. So let's look specifically at some of the rules that are going to apply. And by the way, there's now 550 people in here. Welcome. Thank you all very much for joining us. In case you're just getting in here, we're talking about Michael Cohen. He's going to be the witness right out of the gate tomorrow that we understand is going to be the star witness for Alvin Bragg in the state of New York versus Donald Trump. Star witness time. All right. Moving right along. Let's talk about one of the ways that I would impeach Michael Cohen if I were trying this case. This is Federal Rule of Evidence 608. Again, this is not the New York rules, but again, I'm using the federal rules because these are sort of the model. Every state has something very, very similar to these. They have the same kind of concepts as well. They might be numbered differently. There might be some variations in wording. But a witness's character for truthfulness or untruthfulness is always going to be an issue in the case. As soon as a witness takes the witness stand, their character for truthfulness or the lack thereof always becomes an issue in the case. Hold that thought, because I want to get into some other news so that I'm going to tie all this up here together. Okay. This is from an Associated Press piece. Cohen is expected to take the stand on Monday. Let me show you this one. All right. Cohen's expected to take the stand on Monday, according to this AP piece. The jurors will likely learn that the now disbarred lawyer has not only pleaded guilty to lying to Congress and a bank, but he recently asserted under oath that he wasn't truthful, and even admitting to some of those falsehoods. And there is Cohen's new persona, a podcast, books, and social media posts as a relentless and sometimes crude critic of Donald Trump. All right, so let's see what the next piece says here. Now, this one is from March the 20th of 2024. So this is relatively new as well. A federal judge suggested on Wednesday that Michael Cohen committed perjury under oath. Now, he's not been convicted of perjury, surprisingly enough. And you hear that a lot in the media. You hear people say that he is, and I've said it before myself, but it's technically not true because there's no conviction for perjury. But a lot of people believe he's committed perjury. He certainly has felony convictions relating to untruthfulness and related to lying. And here you have a federal judge suggesting that on Wednesday, Michael Cohen committed perjury under oath, giving fresh support to Donald Trump's claims that his one-time lawyer is an untrustworthy liar. Judge Jesse Furman in Manhattan questioned Cohen's truthfulness in a written order denying his request for early release from probation. With all this stuff going on, if you look at the man's pinned tweet, it is essentially it's a plea to Joe Biden for a pardon, but he's not putting all of his eggs in one basket. He is also trying to get off of probation early by making an application in the trial court, the same court, different judge, but the same court that sentenced him. So he's trying to get off probation early. It was his 3-year sentence for crimes relating to tax evasion, lying to banks, lying to Congress, and violating campaign finance laws. The judge cited Cohen's testimony at Donald Trump's civil fraud trial in Manhattan. On the witness stand, listen to this. On the witness stand, Cohen insisted that he wasn't actually guilty of tax evasion, even though he pleaded guilty to the charge. Now, let me pause just a minute before I come back to this. I want to explain to you all, if you plead guilty to a crime and you take a plea deal, you've got to raise your hand under oath and you've got to swear to certain facts. You have to waive your right to a jury trial and all sorts of procedural rights. That has to be done on the record and under oath. But you also have to admit to what's called a factual basis. You have to admit that you are guilty of the things that you're charged with, because if you're not guilty, you're supposed to get a trial judge absent some very unique circumstances that are not worth discussing right now. There are a couple of small exceptions to this, but you've got to admit that you're guilty before you can plead guilty. And that's the bottom line. Here, he raised his right hand. He swore to God under oath, the same oath he's going to be taking tomorrow to tell the truth in this Manhattan trial against Donald Trump. And he had to raise his right hand, swear to tell the truth, and said he was guilty. All right. So fast forward back to, let's add this back so we can finish looking at it. All right. We've got the Manhattan State Court. All right, on the witness stand, Cohen insisted that he was not guilty of tax evasion, even though he had pleaded guilty under oath to that charge in 2018. Asked if he had lied to the federal judge who accepted his plea, Cohen said yes. So he's testified under oath that he lied under oath. He's testified under oath that he lied under oath. Cohen repeatedly and unambiguously testified at the state court trial that he was not guilty of tax evasion and that he had lied under oath to the late Judge William Pauley. Okay, remember, I'm tying this up to reputation for truthfulness or the lack thereof. So let's get rid of this and let's talk about Rule 608. So witnesses' character for truthfulness or untruthfulness. Witnesses' credibility may be attacked attacked or supported by testimony about the witness's reputation for having a character for truthfulness or untruthfulness, or by testimony in the form of an opinion about that character. So here's what you do. You go ahead and you have a whole parade of people, 10, 15, 20, 80, whatever makes the most sense in your case. You don't want to overdo it, because once you make your point, the jury doesn't want you to keep kicking a dead horse. But you bring in enough people who can testify that, yes, they know Michael Cohen, they are familiar with his character for truthfulness, and that they would not, and based on their familiarity with his character for truthfulness, that they would not believe him under oath. And I submit to you, folks, that that's probably an easy thing for these lawyers to find. They could probably find a lot of people familiar with his character for truthfulness and who would give the jury the opinion that they personally would not believe the man under oath. Maybe they need to call that judge who believes that he perjured himself. But in any event, you can bring witnesses to court that basically say, there's no reason to believe that other guy because he lies all the time. That's the bottom line. These are called, they're called character for truthfulness witnesses. But in this case, it's the character for untruthfulness. All right. So we have talked about bias. We've talked about character for truthfulness. Before we get into convictions, I want to just remind y'all. Let's see here. We've got. Let's see. We've got. What are the convictions for? It was he was convicted of lying to Congress, lying to banks, and tax fraud. All of these things are considered. All of these things are felonies. And, even if it's not a felony, if it's a crime of moral turpitude, something involving dishonesty directly, even if it's not a felony, it can come in. And by the way, a judge will tell a jury that if a person is convicted of a felony, you're entitled to not believe any of their testimony right out of the gate. Now, you can argue about whether that's fair, because some people were committed of a felony years and years ago, and it had, and they've completely, that was a long time ago. It doesn't reflect who they are now. But that's why under the rules of evidence, there's like an age, like if it's more than like 10 years old, it's presumably the kind of thing that's too old that can't be used. But also if the judge believes that, it's just not fair to use against a specific person, the judge has some discretion to keep it out. But other than that, if you're a convicted felon, the judge will tell the jury that before they deliberate that they can ignore all of your testimony. All right. So we're about to start talking about impeachment. And again, for those of you who are just or have just recently joined us in the last few minutes, we're talking about Michael Cohen. He's the star witness in the Donald Trump Manhattan trial that gets back underway tomorrow. And he's got a lot of problems. He is a person who has a tendency to tell a lot of things that aren't true. He tends to lie. He tends to commit crimes. He tends to get convicted for crimes. And he's somebody that has no good character for truthfulness. And we're talking about how the rules of evidence work to provide lawyers who have him on cross-examination the skills that they need to go after him and to show the jury why he should not be believed. And by the way, he is supposedly the star witness. Okay. If you think that nothing that's happened so far in this trial has moved the needle to connect Donald Trump to any criminal activity, well, then you would be in the majority. And supposedly Alvin Bragg says this is the guy who's going to come in and clean it up. This is their star witness. This is on TikTok. He goes out here on TikTok and he makes these videos, and he wears T-shirts that say, that show Donald Trump going to prison. Okay, it shows Donald Trump in an orange jumpsuit behind bars, and he does this in the run-up to his expected testimony. And recently the judge has told prosecutors, you got to tell this guy to tone it down. You got to tell this guy that he's going to have to stop doing all this. The judge, for some reason, doesn't think he has the ability to impose a gag order on Michael Cohen. I think he does, but for some reason, he just doesn't. There's 825 people in here live right now. Welcome and thank you all. Please, before I move on, don't forget, please hit that like button. I see we've got a lot of folks in the chat. And by the way, yes, so I cut my lips shaving yesterday. If some of you are distracted by that, I apologize. It was yesterday, and it's one of the things that's just in the worst possible place. It can't be hidden, and all I can do is deal with it. It doesn't hurt. I can talk, but sorry about that. But wanted to go ahead. I meant to mention that at the very beginning and it slipped my mind, but obviously you guys are pointing it out and I appreciate that. All right. So, wanted to see if there's any questions. And for those of you in the chat, by the way, if you would, I know that you're talking to each other a lot. Sometimes you're talking to me and sometimes you're making comments and responding to what I'm saying, but it's just me right now. I don't have Megan here to help me in the chat. So if you have a question and you put it in the chat, preface it with the word question, say question, and then ask your question. And that way, if you have a question, I'm more likely to see it because I do want to make sure that I answer as best I can any questions that anyone may have. And by the way, if you have different opinions from me, feel free to put those in the chat. We can talk about differences, in how you see these things. All right. I want to, before I get into the next piece of the federal rules here, I want to just touch on what some of this. So we were talking about the judge directs Michael Cohen to zip it on Trump, including his disparaging TikTok videos. So at the close of business last week, Judge Merchan directed the prosecutors to tell Michael Cohen to stop making comments about the case and former President Trump. But he did not impose a gag order. I personally think that he could easily impose a gag order on Michael Cohen, but for whatever reasons he says he's not. I think it's because he's just got a bias. It's either that or he's just stupid. But I think that, or maybe both, but I think he easily could put a gag order on witnesses, particularly ones like Michael Cohen, who have been identified by prosecutors as being the sort of the linchpin to their case. Michael Cohen has been making TikTok videos disparaging Trump, and he's been spotted wearing a T-shirt depicting Trump behind bars. We showed you that. Because the gag order is in place, Trump is not allowed to respond publicly. Merchan told prosecutors to tell Cohen to stop making those kinds of to tell him to stop making those videos and those kind of comments. Merchan told the prosecutors that, and quote, the state's lawyer said they would relay the message. Well, do you think for 1 second that Michael Cohen is going to heed that message? I think not. All right. So here we go. There was some other information in here that I wanted to point out to you. Michael Cohen, okay, experts told Fox News Digital Cohen might have torpedoed the case before taking the stand by ranting about it on TikTok while fundraising. Andrew McCarthy, my friend, says it's a major problem for prosecutors. It's not a problem for Cohen's credibility because he has none. He's a convicted perjurer and a fraudster. Again, he's not, to my knowledge, I've looked this up, he's not a convicted perjurer, but everybody seems to think that he is. But he is convicted of felonies having to do with fraud and lying and he's an admitted perjurer, because we just heard where he told a judge in Trump's civil trial that he admitted to, he said under oath that he lied under oath to a federal judge when he took his plea deal. Anyway, so he was either lying to the federal judge or he was lying to the state court judge. Either way, he was lying under oath. So that makes him a perjurer, whether he's convicted of it or not. All right. It says that Andrew goes on to say he's a fraudster whose current defense of his fraud convictions is that he wasn't telling the truth when he pled guilty. It's a major problem for prosecutors because they chose to build a case on a witness with a track record of bad conduct and deep bias. And not surprisingly, he can't help himself but to continue to act in the character. And all this is true. And this is exactly what we're trying to go through here. We talked about character for truthfulness. We've got plenty of people that will come in under Rule 608 and say, if I know Michael Cohen, I'm familiar with Michael Cohen's character for truthfulness. And if Michael Cohen told me the sky was blue, I would not believe him under oath. So those are the kinds of questions, character witnesses like that. It's not a lengthy examination. You just ask them a handful of questions, But if you get enough people to come in and say they know him, they know his character for truthfulness, it's shitty, and they wouldn't believe him, then that can make a big difference. The prior convictions, we're going to get into that as well. So we were talking about the things that he's convicted of. Rule 609 says that if you have a felony conviction or a crime involving moral turpitude, all you got to do is hit the defendant with that in the presence of the jury. And the way it works is at some point during your cross-examination, you've got in your bag of tricks, you have a certified copy of their plea proceedings. And it's, it might be, a couple inches thick or a few pages, depending on what jurisdiction you're dealing with, but it's going to involve the indictment that they pled guilty to. It's going to have their signature on it. It's going to have the guilty plea statement, and it may have some other associated documents with it. But it's basically the official record of the court, certified with a raised seal and all this, that shows that it is actually, an official court record. And then you can hold it up in dramatic fashion and say, are you the same Michael Cohen that's named in indictment number 12345 in the Southern District of New York, charging you with this kind of fraud and all these other things? Yes, I am. All right. So then you just, and then you just make a big production and make sure the jury sees it, pled guilty, and it's a felony and all this. And that's how, and then if there's more than one, you go through that same procedure with each and every conviction that you can hit him with. And then once that's in the record, you make a big deal out of pointing out that this is something involving fraud. It's involving false statements. If you've got somebody who's already made a statement under oath that they're a liar, that they lie under oath, maybe you use that. Because we have witnesses' prior statements that can be used against them as well. It's usually prior inconsistent statements, things where a witness says one thing one day and another thing the next day. But here we got Rule 613 in the federal rules of evidence. You can use their prior statement against them. And so here's how it works. And if you have lots of prior statements, it's best to have a list of them so that if you're the cross-examiner and you can, if you're the cross-examiner and you want to keep it in order, you just go through and you check them off one by one. And by the way, I thank you very much, Penelope. I always appreciate the super chats. Those are, these are the kinds of things that help us continue to bring new and additional content to the channel, help support the channel in all the ways. Thank you very much, Penelope. So we're talking about prior inconsistent statements. And so what you do is you say, do you remember making or having a conversation with so-and-so at a certain day and a certain time? Yes, I do. And isn't it true that when you talk to that person, you said A, B, and C? So you start out basically saying, so today your testimony is that the sky is blue. But do you remember giving a deposition in a case a year ago? Yes, I do. And in your deposition, isn't it true you said the sky is green? Okay. And then it doesn't matter. And that deposition was under oath and all this. You can do the same thing with a plea transcript, right? Anytime someone is under oath, talking about lying under oath, I believe it can be used here as a witness's prior statement. And prior inconsistent statements, by the way, are also very effective, because what it does is it shows the witness either can't keep their story straight or they're just an outright liar. So there's just so much to work with. These are just some of the examples of the things that you're going to see. But you got to start the whole thing out before you get into the convictions, before you get into the prior inconsistent statements, before you get into anything related to the substance of the questions that were asked. You need to establish that this witness is biased. And when they've gone on TikTok in days, just days before their testimony, and they're wearing a t-shirt showing the accused in this trial behind bars in an orange jumpsuit, what it does is it sets the tone for everything else, because you basically show that there's someone who is not worthy of belief even before the jury is allowed to, even before the jury is told that they're a convicted felon, or even before the jury is told about all the wildly different, various different versions of this event that he's given. But nevertheless, you just go through it line by line by line, item by item by item by item. And if it takes a day or 2 days, then do it. Do all of that. You just basically shred him. And that way, there is no way he can be rehabilitated by a prosecutor. And by that, I mean, rehabilitation refers to the situation where after you've had a witness's credibility or character for truthfulness, you've had them impeached. The prosecutor, if they can, they have the ability to ask questions that are designed to perhaps make them look a little bit better. I don't know how that would work in this case. I'm interested to see what Bragg does, but I think that Bragg's team might actually bring some of this out on direct examination, because if you heard me say earlier in this video that either party can impeach their own witness. And the reason why Alvin Bragg might want to do it is because it takes the sting out a little bit. That's what we call it in the business. You take the sting out of it. You tell the jury, what the problems are with your witness before the other side does, because the theory is you can soften the blow if it comes from you. I don't know if that's what they're going to do. I don't know how they can hide from Michael Cohen's past. I don't know how they can hide from his bias. I don't know how they can hide from any of it. So we may see the prosecutors bring some of this out in a way to sort of control the narrative a little bit before the defense does. All right, we're getting close to 1,000 people in here. I want to check in on the chat now. I want to see if I can let's see. I don't know why it was showing more than 20 likes earlier. Hit the like button. In that way, if it registers late, it registers late. Please hit that like button. That really does help folks find the show. So this, Jennifer says I think Jennifer is probably referring to the jury here. So this brings me to a concern that I've had all along. Donald Trump won in the last election. He won, I think it was 12% of the borough of Manhattan. A lot of people have fled Manhattan and moved to Florida and other places. The local community there the demographics might be less supportive of Donald Trump, but if he has basically such little support in the community, I think it's fair to say that he's probably going to have people on that jury who don't like him, that are anti-Trump. So I think there is a real risk that the jury will ignore all of the flaws and weaknesses, and I think fatal defects in Alvin Bragg's case. And I think they might convict him just because they can't help themselves, because it's Donald Trump and they hate him so much that none of this is the kind of thing that it may not get through. In a rational legal world, you get a witness like Michael Cohen, and if you're a prosecutor whose case hangs on this man's credibility, you don't even bring the case because you know you're dead in the water. But if you're Alvin Bragg in New York with a New York jury, what the hell you got? We got nothing to lose. The deck's stacked in your favor, notwithstanding all of the warts associated with the witness like him. All right. So, yes, I flagged this because Don points out that they will argue, this is going to come in the closing arguments. They're going to say, if you don't like Michael Cohen, all that does is shows you this is the kind of scumbag that the scumbag defendant, hung around with and associated himself with. Therefore, that proves he's guilty. So, yeah, so watch for that. That's absolutely, I think, going to happen for sure. All right. Let's see. Questions, comments, rebuttals, refutations. Again, if you have a question, start out by identifying it as a question. It'll help me see it. Julie, thank you. I appreciate it. Listen, this is, I don't know how much analysis is. This is just, I'm just giving you the nuts and bolts of how the cross-examination would work with a witness like Michael Cohen, who, this is the guy that this is who their case rests upon. And we're talking about convicting the former president of the United States for a bookkeeping misdemeanor, compounded allegedly by another misdemeanor to make it 36 felonies somehow. And this is their star witness. It's the kind of thing, one of the topics for those of you who might be new to this channel, one thing that really is a pet peeve of mine is I believe in the dignity and the sanctity of the judicial process and the judicial system, because it has to be based on fundamental fairness. That's what due process is in the United States. It starts with a fair-minded prosecutor who is objectively seeking the truth and is objectively seeking justice, whatever justice might be. And it's not a prosecutor who's out to get some specific person, but we've got to have a system that that history can reflect on and say, look, no, this was a fair process. And if they convicted the former president, then it was done all above board and it was done for the right reasons, and history would support it. But this notion applies to you and me. If you or me are caught up in the system, the same thing would hold true. We've got to have fundamental fairness in the system. Otherwise, we don't have a system at all. We've just got one railroad express right to the big house or Rikers Island or wherever the case may be. And so I was saying that if you're new to this channel, this is my big pet peeve is I believe in the system being fundamentally fair to all people who are caught up in it, whether it's somebody who's, charged with a murder, whether you're charged with speeding, whether you're Donald Trump accused of, all sorts of things by people prosecuting him for political reasons. Listen, I would have the same if the shoe were on the other foot and this were a Republican DA going after Joe Biden or Barack Obama in a heavily, right-wing conservative jurisdiction. I would have, and for the same reasons that I would have the same complaints about it, because it's not fair. If it's good for the goose, it's good for the gander, as we say here in the South. It means it cuts both ways. Jennifer, thank you very much for the super chat. I really appreciate you, and thanks for being here. And by the way, if I may have missed some super chats, I'll just go ahead and throw this up there in case I miss you. Thank you. Whether I missed you on a previous show or tonight, thank you very much, because that's what helps me keep this channel going. It's what helps me bring additional content. And by the way, if you like the content on this channel, there's always links associated with the show descriptions with some other ways that you can support the channel. So thank you so much. And don't forget to like and subscribe. Thank you, Mike. I appreciate it. Mike says, Phil, would you agree that they know it's a crap case? They know it will get reversed, and all they want is a quick conviction before November. Yeah, I do. I mean, Mike, I think that's exactly what they're going for. You got Bragg's in on it. Bragg campaigned on the Get Trump. He's on the Get Trump plan from the beginning. Merchan, look at Merchan's connections to the far left. And look at the fact that the lead courtroom prosecutor in this case used to be the number 2 or number 3 in the Joe Biden Justice Department, and he steps down essentially to gets homesick, goes back to be a local state prosecutor for Alvin Bragg after leaving a top post at the Department of Justice and Joe Biden's DOJ. Everybody's on the same team here, and they're all on the Get Trump team. And if statistics bear anything out, the jury's also on the Get Trump team, because Donald Trump overwhelmingly lost Manhattan. Overwhelmingly lost it. The best I think that he can hope for is a hung jury, a mistrial. There are 2 lawyers on the case. And, if those 2 lawyers are honest and intellectually honest, even if they are, politically of the far left, if they can at least put their political bias aside and put their lawyer hat on and understand that this is not this is not all above board, and that you can take Michael Cohen and you just can't believe him, the whole case falls apart. So if you get one or two of the lawyers, you might get, or maybe one or two or three of the other people, but a small handful, even if it's just one, can hang this jury, and that would be a mistrial. And you talk about, Mike, you talk about a reversal, and they just want to get this done before November. How many years would it take to have the Court of Appeals reverse the case? Look at the recent reversal of Harvey Weinstein's case. And by the way, why was his case reversed? His case was reversed because the trial judge let in too much immaterial shit that was just brought in purely to slime the defendant. And so they took somebody who's as universally hated as Harvey Weinstein, and the Court of Appeals says, no, this is not a fair trial, and we're going to reverse it. But that was years and years ago now. It's hard to believe, but it was years and years ago. And so, yes, if your only goal is to get a quick conviction, whether it gets reversed, be damned, just get a quick conviction, put the notch on your belt and say, I'm the prosecutor, I'm the judge, that we got Trump, and you go down in history. So I think it's very reasonable to hold that kind of belief, because it certainly looks like that's what's going on to me. All right. Again, thanks for the likes. Make sure you hit the like, subscribe, tell all your friends to subscribe. And I want to answer a few more questions, and point out some other interesting comments I see here in the chat. I can't see them making a bookkeeping fraud case, but there's no victim. I mean, they're calling this a bookkeeping fraud, but it's just like the other fraud. There is no victim. Nobody was hurt here. If this payment was put in the ledger of the Trump Corporation, if it was mislabeled in some way, who is hurt? There's no victim. And it's so bizarre to me. I guess it's maybe a New York thing where you can have fraud where there's no victim. And if I'm Trump's lawyers, I'm going to tell him it's a legal expense. It's the money that was paid was what's called consideration for a contract. A non-disclosure agreement is a contract. People use them all the time, and you might find them to be unseemly, but it happens all that big corporations use them. I'm told that the Fonnie Willis District Attorney's Office here in Atlanta uses them. It's the kind of thing that you have people sign when you don't want them to talk about something, whether it's true, whether it's not true, whether it's something that you should be ashamed of, or maybe it's just routine business. They're used all the time for different reasons. And you can pay somebody to basically not make a claim. You can dispute, like you could say, I didn't have sex with Stormy Daniels, but I know that Stormy Daniels is about to come out and make this claim. And, I don't want this to come out because I'm a public figure and it would be embarrassing to me and my family. So here's some money to shut up and go away, And so this is what we call consideration. It's what makes a contract legally valid and binding, because in the absence of consideration, you've got no contract. So I would tell my client that it is a legal expense. And by the way, it was caught up in a much larger batch of, checks that were going back and forth with Michael Cohen. So, I mean, I just don't know that, first off, there was anything wrong with how the Trump Corporation booked it on their records, but I certainly don't know that that there was any kind of fraud, because there was certainly nobody that was hurt by it. All right. Don, I keep pulling you, by the way. It's not on purpose, but I just see, what's coming up here, and no crime at all. He's trying to shape a non-crime into a criminal offense, adding 2 dubious misdemeanors. Yep. James says a hung jury is what the judge is hoping for to save his ass. That way he isn't held accountable. The jury is. Maybe, maybe, James, that's plausible. But you remember just the other day when Stormy Daniels starts talking about condoms and boxer briefs and all this kind of shit that had nothing to do with the price of tea in China, yet she's allowed to get on the stand and say all this stuff that was highly inflammatory, prejudicial, but still very, very irrelevant, just like all the irrelevant stuff brought into the Weinstein case. There was a motion for mistrial, and it should have been granted. That if the judge was looking for a way to get off the hook, that was it. He could have granted the mistrial, blamed it on the DA, and moved on. But no, he didn't do it. He didn't do it. He decided that he was going to go ahead and allow this farce to continue. All right. Thanks for hitting that like button. I guess YouTube might be a little bit behind the curve catching up, but please, whether you're watching live or you're watching on the replay, please hit the like button, subscribe. And if you like the content, the links are provided in the channel or in the show descriptions for other ways to support the channel. Thank you for all of that in advance. All right. So tomorrow we're going to start out with Michael Cohen. I think Michael Cohen's going to last. I mean, hell, the cross-examination, I could probably do it for 2 or 3 days with him, just going through each and every bit of this. But I'm looking to see if the judge is going to cut Trump's lawyers off at the knees, or is the judge going to allow them to go through all of the things that they could go through. The impeachment by prior conviction, of course, we got plenty of that. Going through his prior inconsistent statement, that could take days and days and days. His character for truthfulness, I could bring in probably 100 witnesses to testify that if Michael Cohen told him the sky was blue, they wouldn't believe it. All right. So you can bring in lots of character witnesses. And again, you've got overwhelming bias, right? That you can point out. And this is not the only example. I mean, you talk about the books and all the other stuff that you can go through his recent, not that, I mean, if you do, you might want to, well, let's just say, I choose not to, but if you want to go listen to his videos he's put on TikTok, feel free. But you can, I've heard excerpts from it, and the stuff that he says on there, he just absolutely lays his bias out there. He doesn't hide it. It's right there for everybody to see. And so you could take those videos and go through item by item, line by line, the things that he says that show his bias. But at some point, I mean, you've already made your case. You just, you can't keep going forever. But I'm wondering to see if the judge is actually going to let the Trump team have as much leeway as I think they're entitled to get into all of these things to show that he's somebody who should not be believed. Jennifer, I assume you're talking about the TikTok photo. Yeah. So this is an interesting, can the defense call Avenatti as a witness? Well, in theory, the defense can call any witness that has relevant testimony. And if Stormy Daniels is any indicator of what the judge thinks is relevant, then yeah, I guess they could. But then you've got one of these questions like, okay, Avenatti has some of the same problems that Cohen has, right? So, I mean, do you really want to go there? If Avenatti has some information that's credible and they think can move the needle, then go ahead and bring it in. But you got to understand, if these lawyers think that they are ahead, if they think that they are, winning, so to speak, they want to get through Michael Cohen. They want to destroy Michael Cohen's believability through all the ways we've been talking about tonight and then some. They want to thoroughly impeach the man so that he can't ever be believed, at least by a rational jury. This, again, we don't know. That's the wild card. This is a Manhattan jury, and the deck might be stacked in favor of the prosecutor too much here to even get over it. But if you think that you're ahead, you might want to just get through Cohen, totally destroy him. You've made a mockery out of Stormy Daniels too. And, I think that at this point, there's been no evidence that connects Trump to any kind of crime. And to the extent Michael Cohen theoretically might be able to do it, Cohen can't be believed for all the reasons we've been talking to you. So you make your case on cross-examination and then you rest. And I don't think you should call Donald Trump either. I don't think you should call Donald Trump as a witness, because not only is that going to take the case into another degree of just spectacle, the media is going to go crazy. They're going to parse every word. And, it's, if you think that you've won the case through cross-examining the prosecutor's witnesses, then you need to stop, whether Donald Trump is your client or not. If you think you've got the case won, or at least in this case, a hung jury would substitute for a win. If you think you've got that, then stop. Sometimes less is more. And I have seen more than one case where it was absolutely headed the way in favor of the defense, and then a defendant testified and did not do all that great, perhaps on cross-examination or even on direct, and then that swayed it for the jury and it wound up being a conviction. So sometimes it's best to take advantage of your right to remain silent and be done with it. I think the general rule is in criminal defense, we expect our clients will not testify unless there's some compelling reason we think that they need to, even if a jury wants to hear from them. But if you've got it won, then you need to just go ahead and rest your case and be done with it. All right. Thank you all very much for being here. We've been at it about an hour now. I appreciate everybody being here. Thanks again for the super chats. Keep an eye on the news, because if you see something big happening in this case, you can bet that I'm going to be coming back here inside the law talking about it. I'm going to be on with Megyn Kelly tomorrow, along with Viva Fry, our friend Viva. He and I are going to be doing a panel with Megyn Kelly tomorrow, so be sure to check us out there. And if you don't catch it live, of course, it'll be on replay, so I'm looking forward to that. But we're going to be following this trial, but also following other things. I expect a notice of appeal. In other news, I expect a notice of appeal to be filed in the Fani Willis disqualification case this week. Just last week, as you know, the Court of Appeals decided they would agree to hear the appeal. So now the formality of filing what's called a notice of appeal has to take place. And then the clerk of court has to send the entire record to the Court of Appeals. The parties start preparing their written briefs on the issue. Once we get briefs from the appellants, and by that, that's the defendants, that's the Donald Trumps, the Michael Romans, the people that are appealing, that are trying to get Fani Willis kicked off the case. They're going to be filing their briefs. I'm going to be getting my hands on them. I'll bring them here inside the law, and we'll go through them like we've done in the past. And the same for the prosecutor. They're going to be filing briefs as well, and I'm sure we'll take a look at those. So if you see it in the news, and if it's legal in nature, there's a pretty good chance that I'll be getting into it here. All right, Mike says there are 2 lawyers and an engineer on the panel. Do you think one might dig in the sand based on the ego of Manhattan professionals? The thing about the engineer, I think I did know that, now that I think of it. Engineers normally, and I hate to paint with such a broad brush, because obviously this doesn't apply to all engineers, but in my profession, when we talk about juries and picking juries and who's on a jury, the conventional wisdom is that engineers are bad for prosecutors. Prosecutors don't want an engineer, while a defense lawyer would tend to keep an engineer, and because engineers like to have everything just so. In other words, they like to have all the dots connected, like proof beyond all doubt versus proof beyond a reasonable doubt. If there's any room for doubt, it tends to be something that might weigh bigger sort of in the minds and in the deliberative process of an engineer than someone who's not an engineer. Now, you get 2 lawyers in a room, the chances of them agreeing on something is pretty slim to start with. So right out of the gate, if you've got 2 lawyers and an engineer in the jury room, that's got to work for Trump's advantage, because if those 3 people can't reach an agreement on it, for even if it's for different reasons, then again, we're perhaps in hung jury territory. And if you're Donald Trump, that's a win. All right. Stay here, chat, follow Inside the Law, follow me on social media on Twitter. Also follow my Inside the Law is on Twitter as well. Follow Inside the Law there, because I will be communicating to you I give you a heads up on what I think I might be able to do when I can find time to get in and do a stream or even a short video. But we're going to be watching all of these things very closely in the next coming weeks. And so it's going to be busy. Thanks again for everyone who's been here. Again, we've got been at it been over an hour. So with that, I'm going to again say Happy Mother's Day to all the moms out there. I hope if you're a mother, I hope you had time to spend with your loved ones. I was able to visit with my now 87-year-old mother and had a nice visit. And I hope that all of you out there have also enjoyed your weekend and your Sunday. And with that, we will see you next time here inside the Law.